So hello everybody, welcome to Vanik's YouTube class on Indian polity. We were pursuing center-state relationship, and we have discussed legislative relations between the central states. Today we shall carry on with the other sort of relationship. I hope you have got, all those who have watched the video must have an idea how the center-state relations work in India and what are the legislative relations. We have divided the legislative relations into 4 subparts, that is territorial extent of central and state legislation, distribution of legislative subjects, parliamentary legislation in the state field, and center's control over state legislation. So parliamentary legislation in the state field and center's control over state legislation and distribution of legislative subjects, all these aspects can also be brought or discussed when you are talked about the restriction of the autonomy of state legislature. So while writing about the restrictions of the limited sovereignty of the state legislature, you can put this point also. The state legislature are not as competent or as powerful as the parliament. There are certain factors which limit their sovereign powers. So the most important is parliamentary legislation in state field. That is in several aspects. When Rajya Sabha passes a resolution, that is Article 249 during national emergency, and when state makes a request and for the implementation of international treaties and conventions, and during President's rule. Also central control over the state legislation are there. The governor, reservation of books, reservation of bills by the governor for the assent of the president sometimes. But the power is limited because governor cannot reserve the bills arbitrarily. Only those bills which have some federal implication, which are related to the organization of High Court, election of the president, implementation of the DPSP, and other factors which have federal character, can be reserved for the governor. So that is why there is a central control over the state legislation, as you can see. And there are also certain things that distribution, in case of distribution also, the state legislature has legislative power over a limited number of subjects, and those subjects are of regional importance only, and subjects of national importance, international importance are put in the union list. Some subjects are mentioned in concurrent list which have common interest and which are equally important not only for the center but also for the state, or those subjects on which a national consensus is essential. These are the concurrent list. And both the center and states can make legislation on the concurrent list. Whenever there is a conflict between the central law and state law on the subject mentioned in the concurrent list, or any law related to the concurrent list, the central law will prevail over the state law. There has been judicial intervention in this case. Doctrine of harmonious constructions has been in place, which states that the entire state law will not be invalid. The contradictory portion of the state law may be scrapped out, may be removed, and the rest of the state law may continue to prevail. That is why it is there, but the constitutional provision is there, so that is called the legislative relationship. Okay, now we shall move to the administrative relationship. The administrative relationship. The administrative relationship. As you can see, in the administrative relationship means the executive relationship. It is found mentioned in Article 256 to 263 in the Part B. In Chapter 2 also deals with administrative relation between the center and state. Apart from these articles, there are also other articles which are related to this matter. Okay. So the executive power has been divided between the center and state completely based on the distribution of legislative powers between them, with some exceptions. The executive of the power of the center extends to the whole of India, to the matters on which Parliament has executive power of legislation, the subject enumerated in the Union list, and to the exercise of rights, authority and jurisdiction conferred on it by a treaty or agreement. Okay, so the executive power of the center, the executive power of the center extend to number one, the matters on which the Parliament has legislative powers. That means the subjects mentioned in the Union list. Are you getting the point or not? Union list. Number two, execution of provisions or statutes related to international treaties and agreements, international treaties and conventions, agreements, etc. So likewise, the executive power of the state government, executive powers of the state extend to the matters on which, very clear, on which the state legislature have the power to legislate, So it is coterminous with the legislative power of the respective legislatures. However, in respect upon which both Parliament and state legislature have the power of legislation, that is the concurrent. The executive power rests with the state except which a constitutional provision or a parliamentary law specifically confers it on the center. That means these are the Union list, list 1 and these are the least two, isn't it? So the state union executive has the executive power on the implementation of laws, implementation of provisions related to the union list, exclusive authority. And apart from that, it has also certain obligations with regards to implementation of international treaties, conventions. Whereas the executive power of the state extend to the implementation of the matters on which the state legislature have the power to legislate. In case of concurrent list, although both the parliament and state legislatures have the power to make legislation on the subjects enumerated in the concurrent list, the executive power mostly rests with the state. So that is the things. You can see whereas on subjects enumerated in the concurrent list, where both the center and state legislates, the executive powers rest with the state, except when a constitutional provision or a parliamentary act specifically confers such executive powers on the center. That means a law enacted by Parliament on the concurrent list shall be executed by the state except the Parliament has directed otherwise. So usually the execution of the provisions related to concurrent list is the responsibility of the state, not the center. Okay, that is the thing of the distribution of legislative power. And there is some obligation of the center and states. In the constitution, there are certain restrictions on the executive power of the state in order to give ample scope to the center for exercising its executive power in an unrestricted manner. So constitution grants unrestricted executive power to the center. Constitution grants unrestricted executive powers to whom? To the center. That means the executive power of the state has some limitation. That that executive power of the state shall be exercised in such a manner so as to ensure compliance with the laws made by Parliament and any existing law which apply in the state, and not to go against or impede the exercise of executive power of the center in the state. Where the former or the first one lays down a general obligation, the latter imposes a specific obligation on the state not to hamper the executive power of the state. If the state hampers the executive power of the center, it may lead to breakdown of constitutional machinery. Okay? So, the executive powers of the state have some couple of limitations, have some or couple of what? Limitations. Such as it must be in conformity with the executive power of the center in the executive power of the center. That means it must not impede, it must not go against the executive power of the center, and it must comply with the parliamentary laws. With the parliamentary laws. The first one is a general obligation, but the second one is a specific obligations. And in both cases, the executive power of the center extends to give such direction to a state as are necessary for the purpose. In the both cases, the center may give direction to the state for these two purposes, and the sanction behind these directions of the center is coercive in nature. That means if a state fails to comply with the central directives with regards to the execution of any provisions, then it may be a ground for imposition of President's rule. It will be lawful for the President that situation arise in that cannot be carried on in accordance with the Constitution. It means in such a situation, President's rule can be imposed in the state that is mentioned in Article 365. So, the center can give direction to the state on any matter related to its executive power in case a state fails to comply with such directives, which such directives it may lead to the imposition of president rule. Hence it is coercive in nature. Hence it is coercive in nature. So that is mentioned in Article 365. So it is coercive in nature. Is that clear? So it is coercive in nature, the obligations. In case of general obligation or specific obligation, that the act must be in conformity with the executive power of the center. That means it must go against the executive power. And it must comply with the parliamentary law or any law that is in practice at this time. So if any center in state executive, any power exercised by the state executive violates the parliamentary law or goes against the norms of central executive, then it will be a solid ground for imposition of precedence. So that is called non-compliance with central directives. Under Article 365, it says that if the state fails to comply with the directives given by the center with regards to implementation or execution of any provision, it will be a ground for imposition of precedence rule, or the president, it will be lawful the president to consider the situation as a breakdown of constitutional machinery in the state and a ground for imposition of precedence rule. Imposition of precedence rule. Okay, so that is, therefore it is called coercive in nature, the obligations. Center's direction to the states. Center's direction to states. In what matter center can give direction to the states? So there are other directions of the center is empowered to give direction to certain specific matter, not only for the execution of central law and provisions, but also for implementation or obedience to the directions, other directions. In addition to the above two obligations, the center is also authorized to give direction to the states with regards to exercise of their executive power in some matters. Apart from the above obligations, center can give direction to the state with regard to the executive power in certain matters, as follows. Number 1, constructions and maintenance of means of communication. That is of communication usually of national importance, but states measures for the construction of railways within the state. Number 3, provision for adequate facilities for instructions in mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350 A. Are you getting my point or not? Minority groups. Number 4, with regards to execution of specific schemes for the welfare of scheduled tribes Look at these four parameters and remember that the coercive sanction provided in Article 365 is also applicable in these cases. If the center does not, if the states do not abide by the directions of the center in these matters, then it will be a ground for imposition of President's rule, and that will be non-compliance with the central directives. So apart from the two above mentioned constitutional provisions, like the central compliance with the parliamentary, that the executive powers to be so exercised that it must be in conformity with parliamentary law and the laws applicable in the state, isn't it? And also it must not contradict to the executive power of the state, center. And in construction and maintenance of means of communication of in national importance by the states, and that will not be denied by the state. Measures to be taken for the construction of railways, and adequate facilities for the instruction in matters of mother tongue. Article 355A. Article 355A deals with this. Article 355A. Okay. And with regards to execution of specific matters, schemes, programs for the welfare of the scheduled tribes in India. That is why it is called center's direction to the states. It's specifically designed. Center's direction to the states. So these are the four areas where the centers can provide directions apart from the two. There is next is mutual obligations. Mutual obligations of functions, executive functions. The distribution of legislative powers in center versus the state is very rigid. Center cannot delegate legislative powers to the state, and a single state cannot request the parliament to make law on the state subject. There is more than one state is required to make a request. So the distribution of executive powers in general follows the distribution of legislative powers. But such a rigid division in the executive power may lead to occasional conflicts between the two. Hence, the Constitution provides for intergovernmental delegations of executive powers in order to mitigate rigidity and avoid a situation of deadlock. The President may, with the consent of the state government, entrust to the government any of the executive functions of the center. Conversely, the governor of a state may, with the consent of the central government, entrust to the government any of the executive powers of the state. This mutual delegation of administrative function may be conditional or unconditional. The Constitution also makes a provision for the entrustment of the executive functions of the center to the state without the consent of the state, but in this case, the delegation is by the parliament, not by the president. Thus, a law made by parliament on a subject of union list can confer executive and impose duties on a state, or authorize on conferring the powers and imposition of duties by the center upon the state, irrespective of the consent of the state. Notably, the same thing cannot be done by the state legislature. So, three parameters. There is the executive powers is related to the legislative power of the central and states. But like the rigid distribution of legislative powers, why it is called rigid? Because Parliament cannot make legislation in the state in without except in certain exceptional circumstances. And the state legislature are not entitled or empowered to make legislation on the union list. But in case of administrative or executive division powers, executive functions, there is some compromise made. President can confer the executive powers. President may confer the executive functions of the center to the state, obviously on the consent of the state, and so also the governor of a state can confer the executive power of the state to the central government with the permission of the latter. So these mutual obligations are sometimes conditional, sometimes unconditional. The Constitution may also make provision for entrustment of the executive function of the center to a state without the consent of the state. But in this case, the delegation is made by the Parliament, not by the President. That means the Parliament can make a law and confer the execution of the law on the state even without the consent. But the state legislature cannot do this type of things. State legislature cannot confer the executive power execution of state law to the center, on the center, without its consent. So therefore, the mutual delegation of functions between the center and state take place either under an agreement or by a legislation. While the center can use both the methods, a state can use only the first method. It can confer its own executive powers to the center only on the basis of only on the consent of the center. But in case of states, center can confer the executive powers both by consent and by obligations. Both by consent and by obligations. Okay, then cooperation between the center and states. Cooperation between the center and states. So, as India is a quasi-federal country, there must be cooperation between the center and state in several matters. It is not always going to be a matter of fight. Rather it is more a matter of fusion. The center and state should cooperate. So, what does the Constitution provide in this regard? The Constitution contains various provisions to establish cooperation and coordination between the center and states. So, the relations the relations between the center and states are not a fight, not of fights, but of fusion. The Constitution contains various provisions to secure cooperation and coordination between the center and states. Number one, adjudication. That is adjudication of interstate river water disputes. River water disputes with regard to the huge distribution and control of interstate river, control of water of any interstate river or river valley and river valley. So disputes arise over many things. Dispute arise over the use of water, dispute arise over the distribution of water, control of water by the upper riparian state, and also the river valley. So Parliament appoints a river water tribunal, or a river water tribunal is constituted under a specific act of the Parliament, like River Act of India. So under Article 262, the Parliament is authorized to do so. Number two, the President can establish an interstate council to investigate and discuss subjects of common interest between the center and states. Between the center and state and among the states. And among the states. Number 3, all the public acts, records and judicial and should be given full faith and credit here all the public acts, records and judicial proceedings of the center and states. Of the center and states should be given full faith and credit throughout the country. Any act made by the state, any state, should not be disrespected, should not be given a negative interpretation. It should be widely given full faith and credit. That amounts to building a concrete relationship between the center and state and among the state too. Parliament can also make or establish national bodies or appropriate authority for facilitating interstate trade and commerce. Number 4, Parliament can establish an appropriate authority Accordingly, Parliament establishes Interstate Trade Council, and with regards to the Interstate Council, the first Interstate Council was set up in 1990. So these are the cooperation between the center and states. So we have discussed cooperation between the center and state, mutual delegation, center's direction to the states, and obligation of the states and the center, distribution of executive power. The cooperation between the center and state is done under these four. Then all India services are there. Like any other federation, the center and state also have their separate public services called central services and the state services respectively. In addition to the two types of conditions, there are also all India services like IAS, IPS and IFS, Indian Administrative Service, Indian Police Service, Indian Forest Service. The members of these services occupy strategic positions or key posts under both the center and states and serve them by turn. But they are recruited and trained by the center. These services are controlled jointly by the center and state. The ultimate control lies with the central government, while the immediate control rests with the state government. So in 1947, Indian Civil Service was replaced by IAS and IPS and were recognized by Constitution as All India Services. Under Article 312, the Rajya Sabha is entitled to establish any other All India Services. Accordingly, in 1966, Indian Forest Service was established as an All India Services. Each of these three All India Services, irrespective of their division among different states, form a single service with common rights and status and uniform scales of pay throughout the country. Though All India Services violate the principle of federalism under the Constitution by restricting the autonomy and patronage of the state, they are supported on the ground that they help in maintaining high standard of administration in the center and as well as in the states. They help in to ensure uniformity of administrative system throughout the country, and they facilitate liaison, cooperation, coordination and joint action on the issue of common interest between the center and states. So there are many claims in favor of the All India Services, but there are also certain opposition to All India Services. Few center-state relation commissions also oppose the provision of All India Services, like the Rajmanar Committee of 1969. But despite that, various commissions of importance like Sarkaria Commission, Kunchi Commissions, they all agreed that All India Service is a necessity, constitutional necessity. Okay, so Ambedkar in Constituent Assembly observed that dual polity, which is inherent in federal system, is followed in all federation by a dual service. In all federation there is a federal civil service, there is a state civil service. In an Indian federation, throughout a dual polity will have a dual service. But with one exception, it is recognized that every country there are certain posts in its administrative setup which might be called strategic from the point of view of maintaining the standard of administrations. There can be no doubt that the standard of administration depends upon the caliber of the civil servants who are appointed to the strategic post. The Constitution provides that without depriving the state of the right to form their own services, there shall be an All India Services recruited on All India basis with common qualifications, with uniform scale of pay, and members which alone could be appointed to those strategic posts throughout the Union. So that is, therefore, All India Service is, although a unitary provisions, have some importance in strengthening the quasi-federal system of the country. They maintain high standard of administrations. They help to ensure uniformity of the administrative system, and last but not least, they facilitate liaison, cooperation, coordination and action on the issues of common interest between the center and states. So they also play a very important role in strengthening the center-state relations in India. Then there are public service commissions under Article 315. They also play a very important role in the center-state relations. The chairman and members of the State Public Service Commission, though appointed by the governor, can be removed by the president. The parliament can establish a joint public service commission, and for 2 or more states, with the request of state legislature concerned, the chairman and members of the JPSC are appointed by the president. The UPSC can serve the needs of a state on the request of the state governor and with the approval of the president. UPSC assists the state by two or more states in framing operating schemes of joint recruitment for any service for which candidates possessing special qualifications is of need. So public service commissions also play aspect of all India services. They strengthen the all India services play a significant role in strengthening help in so these are the major aspect of all India services. Okay, although we have dual services, central services and state services, we have also acquired some certain special services of India services. Then public service commissions in sector state relations, public service commissions. they are dealt in Article 315 and under Part XIB. In the field of publishers, the statutory relations are as follows. The chairman I told you, the chairman and members of the State Public Service Commission, the chairperson and members of State Public Service Commissions are appointed by the governor of the state, but they are removed by the president. Number 2, the parliament by law can establish a joint public service commission JPSC for 2 or more states on the request of the state legislatures concerned. State legislature concerned the chairperson and members of the JPSC are appointed by the president Number 3, the UPSC can serve the need of a state request of the states with the approval of the president. The EPC can assist the states joint recruitment for certain posts for which the candidates require special knowledge and qualifications. Okay, so these are the 4 factors that tells us about the Public Service Commission in the center-state relations. Okay. So these are also a factor of center-state relations. What has been made that you can see the 4 points. These contribute to the center-state relationship. Okay. So the chairperson and members of the state public service commissions are not to be removed by the governor, although they are appointed by him. They are to be removed by the president on certain specific grounds, as the members of UPSC are removed. Then Parliament can also establish a joint public service commission for 2 or more states on the request of the state legislature concerned, and that is there. The chairperson and members of the UPSC are appointed by the president. The UPSC can serve the needs of a state on the request of state governors with the approval of the president. It can also conduct, design and frame the modalities for joint recruitment of certain posts which require special knowledge and qualifications. So these are also play a role in the center-state relationship. Now is the integrated judiciary. Despite India being a federal country, it does not the constitution does not provide for an structurally independent judiciary. We have dual polity, dual government, dual administration, but we don't have dual judiciary. Indian constitution provides for an integrated judiciary. The Supreme Court lies at the apex of the judicial system, and there are multiple number of high courts function under the under this, and there are also certain subordinate courts, district courts, which function directly under the high courts. So there is integrated judiciary. This is done to eliminate diversities or variety in the remedial procedures, that is to provide a uniform remedial procedures. Integrated judiciary is provided. Another thing, the judges of the state high courts are appointed by the president in consultation with the Chief Justice of India and other judges, and the governor of the state. They can be transferred or removed by the president. The parliament can also establish a common high court for adjudication of disputes of the states, with common high court for 2 or more states. There are several common high courts were established: Maharashtra, Bombay High Court, and therefore made for Maharashtra, Goa, and there Punjab and Haryana High Court, a common high court, and Assam High Court, Guwahati High Court. It is also a common high court. So we do not have dual administration of justice. No dual administration of justice. One system of courts of laws on hierarchy with Supreme Court lying at the top, to ensure uniformity in remedial procedure, number is the judges of high courts are appointed by president they can be transferred and although certain grounds, Parliament can make law a common high court for 2 or more states It is under Article 231. So Common High Court can be established by the Parliament under Article 231. There are a number of Common High Courts operating in the country, like Bombay High Court for Maharashtra and Goa, and as you have seen. And in case of Guwahati High Court for Assam, Meghalaya, Assam, Mizoram, Arunachal Pradesh, Nagaland. And there is also Punjab and Haryana High Court. So these are the examples of Common High Court, and they can be established by Parliament. So integrated judiciary is also contributing to towards the center-state relations. And there is also relationship of the center and state during the emergencies. During the operation of national emergency, the center becomes entitled to give directions to state on any matter that the state governments are bound under direct control, complete control of the center during national emergencies. When the president rule is imposed in a state, president can assume himself the functions of the state government and power vested in the governor or any other executive authority of the state. During the financial emergency, the center can give direction to observe financial propriety and can give other necessary directions, including reduction of salaries of persons serving in the state. So relationship during emergencies, relations between the center and state during is also a point. Relations between center and states during national emergencies, during emergency, you can say. So during national emergency, under Article 352, the state governments are brought under complete control of the center, though they are not suspended. During constitutional emergency, the president can assume vest them. During under Article 360, and prudence of the states. The State Election Commission, though appointed by the Governor of the state, can be removed by the President. So these are also some other provisions you can list also. It also work in favor of in the interest of the center-state relations in India. Article 355 that is impose two duties on the center to protect the state against the external aggression and internal disturbances and ensure that the government of state is carried on in accordance with the constitution. If the government is not carried on in accordance with the constitution, the center may impose constitutional emergency either on the report of the governor or on its own convictions. And the governor is expected to act as is expected not only to act as a constitutional head of the state but also as an agent of the center, and it is the duty of the governor to submit an annual report to the president on the administrative affairs of the state. The State Election Commission, though appointed by the center, are removed by the appointed by the governor, removed by the centers. Apart from that, these constitutional provisions that we have seen, lot of center-state relations point we have in administrative field. Apart from these constitutional provisions, there are also certain extra constitutional provisions mentioned in provided in India to contribute towards strengthening the center-state relations. The role of Niti Aayog in this regard stands out. The role of Niti Aayog plays an important role in promoting cooperative federalism and bringing the states and the union government to the table or to a common platform and decide their own fates. Then the National Integration Council, Central Council on Health and Family Welfare, Central Council of Local Self-Government, the Zonal Councils, Northeastern Council of the Center, Central Council on Medicines, Central Council on Homeopathy, Transport Development Council, University Grants Commission, they all act as a non-constitutional advisory bodies towards strengthening the constitutional system. Okay? So these are the things, and apart from that, there are also certain important conferences, extra constitutional provisions or extra constitutional provisions or extra constitutional norms which also facilitate center-state relations. There are certain conferences held periodically, the Governor's Conference, the Chief Secretary's Conference, the Conference on Inspector General of Police, the Chief Justice Conference, the Conference on Vice Chancellors, the Home Ministers Conferences presided by the Central Home Minister, the Law Ministers Conferences, the conferences of the Chief Ministers presided over by the Prime Minister, the Governors Conference are presided over by the President. So these bodies act also contribute towards smoothening the administrative relations between centre and states. So we have seen there are several constitutional and extra constitutional mechanism and provisions for building an effective center-state relations in India. So with regards to extra constitutional devices, we can say that in the above mentioned constitutional devices, there are extra constitutional devices to promote cooperation and coordination between the centre and state, and these include a number of advisory bodies and conferences held at the centre. I have told you the advisory bodies like Niti Aayog, National Integration Council, the Central Council of Health and Family Welfare, the Central Council of Local Self-Governments, that's the Medical Council of India, the Zonal Councils, the Northeastern Councils, the Council on Medicines, Central Council of Indian Medicine, the Central Council of Homeopathy, the Transport Development Councils, University Grant Commissions. Okay, there are certain bodies like your SSCs and Staff Selection Commissions. So these are the bodies which contribute towards strengthening center-state relation. Apart from these councils, apart from these advisory bodies, there are also certain conferences held periodically which contribute towards strengthening the center-state relations, and they are Governors Conference, Chief Ministers Conference, Chief Secretaries Conferences presided over by the Cabinet Secretary, Chief Justice Conferences provided by the Chief Justice of India, Conference of Vice Chancellors, Conference of Home Ministers, Conference of Law Ministers, so and so on. Okay, so we can see there are ample arrangement made for effective administrative relations between the centre and state. So we have discussed two major relationship between centre and state, that is legislative relation and centre, your administrative relation. In the next class we shall start with the financial relations between centre and the states. Next class. It is financial relations. Okay, guys, thank you very much for watching us. Vanik, the mega institution which confers this facility to all of you. Avail these facilities, provide your constructive comments, and help us to improve our mission, to improve our initiatives, so that we can do best to fulfill the needs and aspirations of our students. Thank you again for being with us and for watching our classes on YouTube.